This video will help you prepare for your first mediation session. We suggest checking out our video titled, "What is Mediation?" first. It explains the basics of mediation. In this video, we'll cover different mediation styles, walk you through the process, and share some handy skills to use during the session. We'll also quickly talk about legal help and who needs to be there. We will conclude with tips for online and physical sessions.
There are three main styles of mediation. Each style has a different focus and a different role for the mediator. First, there's facilitative mediation. This is the standard style of mediation. The mediator facilitates communication and helps parties explore their interests, but doesn't evaluate the case or suggest solutions. The mediator asks questions, reframes issues, and guides the process while the parties develop their own solutions. Facilitative mediation is best used when parties need to preserve relationships, family or neighbors, workplace, when creative solutions are possible, or when emotional issues need to be addressed. It is best for disputes where the parties will have ongoing contact. Evaluative mediation. During an evaluative mediation, the mediator assesses the strengths and weaknesses of each side's case, predicts likely court outcomes, and may suggest settlement terms. The mediator acts more like a neutral advisor with expertise in the subject matter. Evaluative mediation is best used in legal or commercial disputes where parties want an expert opinion on their case's value, when parties are far apart on settlement numbers, or when they need a reality check about litigation risks. Common in personal injury, employment, and business disputes. Transformative mediation. A transformative mediation focuses on empowering the parties and helping them recognize each other's perspectives. The goal is transformation of the relationship and the conflict interaction itself, not necessarily reaching agreement. It is best used when the relationship itself is the priority. Family disputes, workplace conflicts, when parties feel disempowered or misunderstood, or when emotional healing matters more than a specific outcome. This style is often used in community and interpersonal disputes. It is important to discuss your mediator's style to ensure it is a good fit for your dispute. Evaluative mediation requires a mediator with strong legal or technical expertise in the subject matter, while transformative mediation demands exceptional listening and empathy skills. Understanding your mediator's style will help you determine whether the approach matches your needs, prepare more effectively, and participate more actively in the process. Our practice uses the Agile method and use all three styles. We'll discuss the best style to start the session, but we might pivot to another style to adapt to emerging emotions and new information.
Here is our general process. A private mediation is typically completed within a few days to a few weeks. 1. Initial contact and vetting. You or your attorney contact us. We will perform a conflict check to ensure we have no conflicts of interest that would compromise neutrality. 2. Mediator selection. All parties must agree your mediator is a good fit and your case is a good fit for mediation. We will then sign a mediation agreement that outlines the process, fees, usually split, and confidentiality rules. 3. Pre-mediation session call. We will schedule a call with each party to ensure that everyone is aligned on logistics, process, and key issues before the formal mediation session. We will detail on the next slide what will be covered during that important call. 4. Information exchange. Parties exchange relevant documents, financials, issue statements, etc., with each other and/or the mediator. 5. The mediation sessions. After a brief opening statement from the mediator and each party, there is typically an exploratory joint session, followed by other joint sessions or individual sessions, also called caucuses. These sessions typically result in a negotiation and drafting phase. 6. Memorandum of Understanding, or MOU. If a full agreement is reached, the mediator drafts a summary of the terms. This document summarizes agreed terms. Whether it is legally binding may depend on jurisdictions and specific language used. Parties typically treat it as a roadmap for the formal agreement. 7. Legal review and formal drafting. Attorneys, if involved, review the MOU, and a mutually agreed upon attorney or the parties themselves may draft the final agreement. 8. Signing and finalizing. Both parties sign the final agreement. If no lawsuit is pending, this document simply becomes a binding contract between the parties. If a lawsuit is pending, this document is filed with the court. Some important reminders. The mediation is voluntary, and either party may withdraw at any time before the final agreement is signed. Also, the mediator facilitates discussion and may help draft terms, but does not impose decisions. You and the other party negotiate and craft the agreement together.
The goal of a pre-mediation call is to set the stage for a successful and efficient mediation. It is a preparatory step that helps ensure that everyone is aligned on logistics, process, and key issues before the formal mediation session. This preliminary conversation is crucial for minimizing surprises, building rapport, and maximizing the chances of reaching a resolution. Here is what is usually covered in our call that typically lasts about 1 hour. 1. Understanding dispute and clarify key issues. We will discuss the case background. I will ask you for a brief summary of the dispute, its history, and the current legal or procedural status. The core issues. What are your primary points of contention? This helps prioritize the issues and give us a sense of time needed for the session or sessions. Any prior settlement discussions? Did you attempt negotiations in the past? What were the sticking points or impasses? 2. Logistics and participation. We will confirm who will attend. We need to confirm that all necessary parties with full settlement authority will be in attendance, whether in person or virtually. This is particularly important for corporate or insurance cases where a representative might need to consult with a superior. Settlement authority. We need to confirm that the individuals attending have the authority to make a final decision and sign an agreement on the day of the mediation. Logistics. This includes confirming the date, time, duration, and location, physical or virtual, as well as any special needs or accommodations. 3. Gauging the emotional and interpersonal dynamics. Mediation is often as much about human relationships as it is about legal facts. We will review the emotional state of the parties. What is the emotional history and current emotional state of the parties? Are you or are they angry, anxious, or particularly stressed? This insight will help me anticipate potential roadblocks and determine if a joint session is even appropriate. Be aware that I will screen for power imbalance and domestic violence. Your goals and interests. I will ask you what you hope to achieve, moving beyond the stated legal position to the underlying interests. For example, your interest might be a public apology or the preservation of a business relationship, not just a monetary settlement. 4. The mediation process and expectations. We'll finish the call by clarifying the process and managing expectations. You will be encouraged to watch this series of videos to better prepare yourself to your mediation session. We'll finish by reviewing the process. I will tell you what the mediation session will be like, and we'll discuss the process. The process may change, as I might decide before or during the session to try another method. For example, I may decide to skip the joint session and do caucuses or private sessions if I feel a high level of animosity between the parties. We'll finish by reviewing written submissions. I will provide instructions on what written materials to submit before the mediation, such as a mediation statement, and set a deadline for their submission. Ultimately, the goal of a pre-mediation call will be to ensure all parties understand the mediation process, have the necessary information and people present, and are prepared to negotiate productively on the day of mediation.
Before mediation, I will ask you to prepare a statement that summarizes the case from your perspective. I will not share the statement with the other party, but you may choose to do so yourself. This statement will help you organize your ideas and can be used for your opening statement during the mediation. When writing your statement, focus on clarity and conciseness. State your perspective of the situation, the key issues you believe need to be addressed, and what you hope to achieve in the mediation, all without resorting to emotional language or personal attacks. Here are questions you may want to ask yourself when preparing the statement. First question: what is important for me to share during mediation? Unlike in court, where parties have a limited opportunity to speak, mediation gives you an opportunity to talk about what really matters to you. It may be useful to know ahead of time what you'd like to talk about or to hear another person at the mediation talk about. Do you want to discuss your or their experience, how you or they have been impacted, how you or they are feeling? Second question: what do I expect from the mediation? In most cases, a court can only order money damages if they rule in favor of a plaintiff. In mediation, you may ask for other things that are often not available in court, like an explanation, an apology, and items to be returned, a better relationship, at least a step towards it, or the end of a relationship, called a no contact. Third question: do I want money retribution? If so, how much? If you want monetary reparation, be ready to justify how you calculated the amount. Fourth question: what if mediation fail? Before attending mediation, it is helpful to understand what your options are if mediation doesn't result in a settlement. What if you don't settle the case in mediation? Fifth question: am I ready to listen? To be a productive mediation session, you will need to be prepared to listen to what the other party has to say. But listening to wait to talk are two different things. Ask how you can prepare yourself to listen with the intent to understand and not just preparing your reply.
Here are some skills you could learn to be better prepared for mediation. In the next few slides, we will learn what is a win-win negotiation and how you achieve it, what is nonviolent communication and how to use it to better communicate, how to de-stress during a conflict, how to write your goals and must-haves, how to think rationally by writing down your best and worst-case scenarios if you don't reach an agreement during mediation.
Let's briefly explore what win-win negotiation means and how you can learn more about this approach. Win-win negotiation, also called integrative, collaborative, or interest-based negotiation, is an approach where parties work together to find solutions that satisfy both sides' core interests, rather than competing over fixed positions where one person's gain is another's loss. The magic of mediation often happens when parties move from arguing positions to understanding each other's interests. Positions are what people say they want, their stated demands or solutions. Meanwhile, interests are why they want it, the underlying needs, concerns, fears, values, or goals driving their position. Positional bargaining leads to a win-lose mentality. to deadlock or suboptimal compromises and often damage relationships. Interest-based negotiation allows creative solutions that satisfy both parties, multiple options for resolution, preservation or improvement of relationships, and solutions neither party initially considered. Let's take an example. If a party's position is, "I want $50,000 for this breach of contract," the possible interests behind it might be, they need to cover actual financial losses. They want acknowledgement of wrongdoing. They fear of looking weak. They desire to prevent future breaches. They need for business relationship to continue. Or they might want public vindication. A litigation will ask, who is right? What can be proven? What does the law require? A mediation will review what both parties actually need and how they can both come out ahead. Litigation is often a zero-sum game where both parties lose, even if one party may lose less than the other. With mediation, there's a potential for a win-win where both parties are better off than if they'd won in court. In our case, mediation can address interests that litigation cannot touch: acknowledgement, relationship preservation, future security, reputation management, and creative financial arrangements, while costing significantly less. Mediators are trained to uncover interest by carefully crafting questions, listening for emotional cues, exploring what-if scenarios, and looking for patterns. If you want to learn more about win-win negotiation, here is a great book, Getting to Yes by Roger Fisher, William Ury, and Bruce Patton.
Learning nonviolent communication will be useful during mediation. Nonviolent communication, or NVC for short, is a communication framework that focuses on expressing yourself honestly while listening empathetically to others, without blame or judgment. The 4 components to NVC are observations, not evaluations. Describe what you see or hear factually. Feelings. Express your emotions without blame. Needs. Identify the underlying needs or values driving your feelings. Requests, not demands. Ask clearly for what would meet your needs. So the formula is, when I see or hear ... I feel ... because I need ... would you be willing to ... Let's use an example.
You're a deadbeat. You ignored 3 invoices. You're trying to cheat me out of my money. I'm never working with you again.
This is an example of violent or judgmental communication. The other party will be defensive and will stop listening to you to prepare his own attack. At this point, negotiations are over. Here's the same idea expressed with nonviolent communication.
When I didn't receive payment within the 30 days we agreed upon, I feel stressed and concerned because I need cash flow to pay my own suppliers and employees. Would you be willing to discuss a payment schedule or let me know what obstacles you're facing?
Let's use another example. Here's the violence communication.
You're lazy and incompetent. You haven't brought in a single new client in 6 months. You're destroying this business.
Here is the nonviolent version.
When I see that our client roster hasn't grown this quarter, I feel anxious and overwhelmed because I need to know we're both equally committed to business development and that the workload is balanced. Would you be willing to discuss how we each see our roles and what support you might need to focus on new business?
One last example. Violent or judgmental communication.
You're a slumlord. This building is falling apart and you don't care about your tenants. You're breaking the law.
Nonviolent communication.
When the HVAC system has been non-functional for 3 weeks, despite my repair requests, I feel frustrated and concerned because my employees need a safe, comfortable work environment, and I'm at risk of losing productivity. Would you be willing to either repair the system within 48 hours or reduce rent proportionally until it's fixed?
NVC reduces defensiveness and will help you being heard, and the needs component naturally reveals underlying interest. And if you remember from a previous slide, this is the basis to win-win negotiation. NVC also creates empathy. I need financial security to pay my medical bills is more compelling than I want $50,000. And it helps you move from blame to solutions. Good mediators know how to use NVC with their own statements, and they will help you reframe a violent statement and coach parties to express themselves without blame. NVC is a very valuable skill to de-escalate emotional situations, not only for mediations, but also in your personal and professional life.
You might be stressed about the ongoing lawsuit or confronting the other party at mediation, and it might feel huge right now. Litigation and mediation are emotionally taxing, but here are some techniques to help you to relax and keep you in the right frame of mind. Mediation is an informal process. Think of it less as a confrontation and more as a structured conversation with a neutral referee. You're not walking into a courtroom drama. You're sitting down at a table to solve a problem. The mediator is there to keep things calm and productive. And unlike court, where a judge decides your fate, in mediation, you control the outcome. Nothing happens unless you agree to it. If you don't like what's being discussed, you can say no. That's less stressful than putting your life in a stranger's hands. You are better off being well prepared, so put some work in preparing your mediation to feel in control, but once you have done the work, try to set it aside mentally. Don't ruminate it. Instead, imagine yourself 6 months from now. Imagine yourself at a time when the awkward moments or sweaty palms of mediation are long gone, and all you care about is to have the dispute solved. For the day of mediation, arrive 15 minutes early so you don't have to rush, and bring a book or a good podcast to occupy your mind while waiting. Think of mediation as a business meeting and dress and talk accordingly. And remember that the other party is probably as stressed as you are. Share with your mediator your level of stress in advance so he can adjust to it and make you feel more comfortable. Learn breathing techniques. For example, learn the 4-7-8 breathing technique. Inhale for 4, hold for 7, exhale for 8. It sounds silly, but it genuinely calms your nervous system. Take breaks. I encourage you to take a break whenever you feel tired or overwhelmed. Go out for a walk, climb some stairs, get some fresh air, or simply go to the restroom and splash cold water on your face. Set realistic expectations. Remind yourself that a successful mediation often means compromise, and that the final outcome may not be exactly what you initially wanted. The goal is to reach a resolution that is better for everyone involved than continuing the dispute. Lean on support. If you have a lawyer, rely on their counsel for guidance. Attorney-client privilege protects your conversations. If you have a trusted family member or friend, you can call them during a break for support, but be mindful of the confidentiality of the proceedings. You can call a friend for emotional support without discussing specifics. You are not allowed to discuss specific statements, offers, numbers, or strategies. A breach of confidentiality may have legal consequences.
Mediation moves quickly, emotions run high, and you'll face pressure to make decisions on the spot. So even if you do have to agree to anything, this is the principle of self-determination. Being prepared will be helpful. Without clear goals and boundaries defined beforehand, you risk 2 critical errors: accepting a settlement you'll regret later because you felt exhausted or pressured, or rejecting a reasonable offer because you're caught up in the moment's frustration. By identifying your ideal outcome, acceptable outcome, and non-negotiables in advance, you create a roadmap that keeps you grounded when negotiations get intense. These aren't just wish lists, they're your decision-making tools. First, write down the ideal outcome. This is your best-case scenario if everything goes your way. For example, in an employment dispute, the ideal outcome could be full back pay, reinstatement to your position, written apology, removal of negative performance reviews, promotion consideration, and coverage of all legal fees. Second, write down your possible acceptable outcome. This is what you can realistically live with. You would not be thrilled, but satisfied. For example, in a divorce or custody dispute, an acceptable outcome could be joint custody with you having primary residence during school year, alternating holidays, keeping the home or equivalent equity, and 55% of retirement assets. And third, write down your non-negotiables. These are your absolute deal breakers. If these lines are crossed, you walk away. These are issues tied to your safety, values, or fundamental rights. For example, in a business dispute, the non-negotiables could be must receive at least 50% of owed payment, cannot accept terms that admit liability for damages you didn't cause, and will not sign away the right to work with other clients. During mediation, when an offer comes across the table, you can quickly measure it against your predetermined criteria, rather than making emotional, reactive choices. Your ideal outcome shows where to aim. Your acceptable outcome shows where you can realistically land, and your non-negotiables protect you from crossing lines you'll regret. Think of this exercise as your anchor. When the mediation gets turbulent, these written goals keep you steady and ensure you make decisions aligned with your true interests, not just your in-the-moment emotions.
Often during caucuses, which are one-on-one sessions, your mediator will help you do a reality check and help you stop thinking emotionally and start thinking rationally. Going from, I deserve $200K to, what is my best and worst case scenario if mediation fails? Your best and worst case scenarios are called BATNA and WATNA. BATNA stands for Best Alternative to a Negotiated Agreement. It's what you'll do if mediation fails and no agreement is reached. It's your backup plan, your best option outside of settlement. A strong BATNA means you have negotiating power. WATNA stands for Worst Alternative to a Negotiated Agreement. What's the worst case scenario if mediation fails? What's the most negative outcome you could face? The WATNA is about risk assessment. It helps you understand how much uncertainty you're accepting and motivates realistic expectations. Your settlement range should be at least between your WATNA and BATNA and possibly better than your BATNA. Here are some questions you should ask yourself. All these questions and many more should be taken in consideration when you are doing your BATNA and WATNA. How much damages can you actually prove? What is the cost of discovery? Do I need expert witnesses? What if the other side appeals? Will I need to pay the other side's legal fees if I lose? Do I have the money for legal fees now, or will I need to borrow? How much work time will I lose attending depositions, meetings, trial? What are your chances to win at trial? How long will the trial last, and what would be the cost? How long will it take to actually collect money if I win? Will they file bankruptcy to avoid paying? How many hours will I spend with my attorney preparing? Does the relationship with the other party matter? What will be the emotional toll? How will it affect me in terms of health and stress level? What will happen to my family or business during the months of litigation? Will it damage my reputation if I lose? How about if I win? In essence, the best outcome of mediation is for all parties to make the wisest possible decision for their circumstances. It could be crafting a win-win solution, getting clarity on the dispute, repairing a relationship, or proceed to litigation. It's about empowerment, informed choice, and often peace of mind.
Speaking with a lawyer before or between mediation sessions is strongly recommended, even if you choose not to bring an attorney to the mediation itself. A lawyer can help you understand your legal rights, evaluate potential settlement options, and ensure you're making informed decisions throughout the process. While mediation is typically less formal than court proceedings, the agreements reached can have significant legal consequences, making a legal consultation valuable. You have the right to bring a lawyer with you to mediation sessions. Some parties choose to have their attorney present to provide immediate guidance, while others prefer to consult with counsel privately before and after sessions. You may wonder, what is the point of mediation if you need a lawyer? Mediation still offers significant advantages. It's typically faster, less expensive, less adversarial, and gives you more control over the outcome than going to court. Consulting with a lawyer doesn't eliminate these benefits. Rather, it helps ensure that any agreement you reach protects your interests and rights. Your state's court website can be a useful resource for finding qualified attorneys in your area and for accessing general legal information about mediation and family law matters. If you cannot afford an attorney, free or low-cost legal assistance may be available. Visit www.lawhelp.org to find legal services organizations in your area. Many of these organizations offer legal advice, brief consultations, or full representation to those who meet income eligibility requirements. Some may also provide self-help resources and informational workshops about mediation and related legal processes. It's important to understand that court employees cannot provide legal advice, help you decide whether mediation is appropriate for your situation, or recommend specific mediators. Court staff can offer procedural information and direct you to available resources, but questions about your legal rights and options should be directed to a licensed attorney.
Who should attend mediation? 1. Parties to the case. Anyone named in the court case should be present. They are the decision makers who must agree to any resolution. 2. Attorneys. Each party's legal representative may attend if the party wishes. This is the party's decision. No one else, including the other party or mediator, can restrict an attorney's attendance. 3. Additional attendees. Other stakeholders. People not named in the case but involved in the subject matter or affected by the outcome, such as family members or financial advisors. Support people. Individuals who provide emotional or moral support, such as a friend, family member, or counselor. Their role is to provide support, not to speak for the party or participate in negotiations. Note that these additional attendees may attend only if all parties and the mediator agree in advance. Interpreters. If you need language assistance for court-referred cases, contact the court clerk or ADR coordinator for interpreter services. For a private mediation, discuss interpreter needs with your mediator in advance. Maintaining balance. There should not be a significant disparity in the number of attendees between parties, as this creates a power imbalance. For example, if one party brings multiple supporters while the other comes alone, the solo party may feel outnumbered and intimidated. The mediator will help ensure a balanced environment where both parties feel comfortable negotiating. Who should not attend? Witnesses who would only testify at trial typically should not attend mediation. Mediation focuses on negotiation and problem solving, not presenting testimony. Important, discuss attendance with your mediator before the session. Bringing last-minute participants creates surprises that can damage trust and may cause the other party to end the mediation.
What is the dress code for mediation? Be comfortable, but show everyone respect for the process. Dress to create a professional and respectful atmosphere. If we hold the session online or in a private office, business casual attire is best. If we hold the session in a courthouse, more formal attire will work best. Match the context. For example, if this is an employment dispute, wear what you would wear to the office. But be mindful of comfort. Wear comfortable shoes and clothes. You might have to walk quite a bit and sit for hours. Some tips for online mediation. Solid colors work best. Avoid busy patterns, stripes, or bright whites that can be harsh on camera. Dress fully professional even below the waist. It affects your mindset and prevents accidents if you stand up.
Here are some tips for physical face-to-face mediation. Before the mediation, gather your documents. Bring copies of all relevant documents such as financial records, contracts, correspondence, photographs, or other materials that support your position. Organize them so you can easily reference them during discussions. Be prepared. Educate yourself on win-win negotiations, practice nonviolent communication, write down your BATNA and WATNA. Reread your mediation statement. On the day of the mediation, arrive early. Plan to arrive 15 minutes early. This gives you time to find parking, locate the room, use the restroom, and settle in before the session begins. Bring essentials. Pack water, snacks, any necessary medications, phone chargers, and materials to keep yourself occupied during breaks. Bring something that helps you relax, like a stress ball or fidget toy. Or a comfort object, like a small meaningful item such as a photo, smooth stone, or piece of jewelry that grounds you. You may also want to bring tissues if you expect an emotionally heavy session. Plan for breaks. You can request breaks when needed. Use this time to stretch, clear your head, consult privately with your attorney, or step outside for fresh air.
These tips are for online mediation. Make sure you are in a quiet, private room. For confidentiality requirements, no one should be able to hear you, and no one should be coming in and out of the room. For the background, use a clean, uncluttered wall or bookshelf or neutral background. Avoid bright colors, messy bedrooms, or pets. Avoid virtual backgrounds or blurred backgrounds. They can be distractive. Make sure you face a window or lamp. Light should hit your face. If you have a light source behind you, it may obscure your face. Camera positioning is important. Put the camera at eye level, not looking up or down at you. Frame the camera angle close enough to see your entire face clearly. Frame it like you would for a photo ID. Lighting and framing is important. The goal is to clearly show your facial expressions. Have a comfortable chair. The session might last a few hours. Make sure you request breaks when you need them. A few notes on the technology. If you use a laptop, make sure it is plugged in or fully charged. Video conferences use a lot of power. Laptops may not have the best video and audio setup. Use a headset if you have one. Have a backup device like a phone or a tablet with you. Use a reliable internet access. If you use a phone or tablet, make sure they are plugged in and find a good way to have them on a stand at eye level. Don't hold your phone. If you need, make a stand with boxes, books, or a yoga brick. Make sure all your devices have their notifications turned off. Tell people in your household to be quiet and not interrupt, and join the call 15 minutes before the session to test your audio and video. Here are a few items you should have with you, but make sure they are kept off camera. Have a bottle of water near you and a snack for a long session. Have a notepad and pen if you want to write notes. Have a box of tissues just in case.
Preparing for mediation isn't just about gathering documents and understanding procedures. It's about preparing yourself mentally, emotionally, and strategically for a conversation that could resolve your dispute and move your life forward. Mediation is not about winning or losing. It's about making the wisest decision for your circumstances. The person who wins at mediation isn't necessarily the one who gets the most money or the most concessions. The real winner is the person who walks away with clarity, closure, and a solution that serves their genuine interests better than the alternatives. Remember, you control the outcome. Nothing happens unless you agree to it. The mediator facilitates, but you decide. That power, combined with the preparation you've done, means you're walking into that room not as a victim of circumstances, but as an empowered participant ready to resolve your own dispute. Take a deep breath. Trust your preparation. Listen with genuine curiosity. Speak your truth without blame. And know that whatever happens, you've taken a courageous step toward resolution. You've got this.